will record it.
No, Millard keeps it tomorrow, Millard. I'll ask my advocate on record if he is coming back today to at least bring the client or affirm an affidavit or some sort of.
The client can come even if the advocate on record is not there.
Or both of us, if you can file an
Then
affidavit.
only this matter will keep it part, otherwise not. On this, I
Yes, by
I was
consent
very
of both.
disappointed. I'm sorry, I did not utter a single word.
We are also.
No. Those
Have we responded?
appellant
We
petition.
have heard the letter. From date,
Millard,
terms of settlement within 1 week from date,
Yes. Or 10 days, my lord, to be on the safer
safer
side, I understand.
within 10 days from date. The matter shall be listed as a part-heard matter.
deeply obliged.
Here's 5.
My lord, 26 June, my lord, there was an interim order.
The interim order passed earlier. The interim order
I am obliged.
Deeply obliged.
5 to 9. Make it not today only. Make it not today. We are not taking this matter. One day we cannot finish it off. So. Next. At number 10.
5 to 9?
Not today, we make it not today. Sorry. 10.
And I am for the respondent.
What is this matter?
May I file my
Section 37 appeal, section 34 has been dismissed.
It has to be heard.
Millard, only, Millard, since my lord, the point is interesting, my lord, we were wanting if lordships, my lord, can hear it, and my lord, the point, my lord, after now a new point has been taken, whether MSME is applicable to works contract. This is the point which they have taken for the first time in the section 37 stage.
You want this, any paperwork is required to be filed?
No, my lord, all the papers are there.
Take down. Oh, section 5.
Section 5 and a stay.
No, my lord, till date I have not filed any stay applications.
No, stay petition is there.
No, it आपने ये थी, the memo of appeal.
Section 5 we dispose of 13 days delay. Take down.
Very well.
There is a delay of 13 days. the defects or not. It is not being formally registered. It has to be formally registered now. Maybe 1 day's time, but it will be.
Right.
11, no, section of 5 to dispose of it.
So my lords are pleased to dispose of only the can, the section 5.
Not today, make it not today. 11. Well, what is-
I think I should, my lord, withdraw this appeal.
I see.
My lord, I'll tell your lordship what happened. There was an order passed. Third party, my lord, to a probate proceeding was given leave, my lord, to inspect records.
Okay.
Subsequently, my lord,
I'm
he's
appearing
also
for the
lodged a,
intervener.
subsequently, he's also lodged a caveat. He's also lodged, my lord, filed an affidavit in support of caveat. And I have filed
So
for
that order becomes,
Yes, and this is an appeal from that order. So I have now filed an application for discharge of caveat, which is going to
I
be
see.
heard. So
Take
the
out.
only request, my lord, is if your lordships permit, all points to be left open to be decided.
in view of client is
My Gautam Roy, my lord, there is an intervener, my lord.
by which Mr. Gautam Rai.
I'm late by Mr. Bachchan.
Yes.
জিষ্ণু তুমি অনেকদিন
12, 12, 12.
আজকে আমার গল্প মাই গুড লাক
Oblige, my lord.
Every day I do a calculation.
ভুলে গেছি
Section 34.
No, we appeal from an ex parte decree. Our point is that when your lordship presiding over a division bench transferred the suit to the commercial division. However, thereafter, the plaintiff continued with the suit as if it is filed in the original exercise of original jurisdiction. And sometimes it was heard in the
Who
commercial.
is your other side?
Mr. Devnath Ghosh was appealing.
We'll pass it over once. If he's there, we'll see. Yes, next.
Lord, in the meantime, Lord, I think your lordship's judgment in another matter may be relevant to this. But I forgot to tell Mr. Sen that there's been one judgment on this point, perhaps by your lordship, Lord, in another court.
Appeal from a restoration.
Huh?
We had preferred the appeal
Yes,
from the
yes.
restoration.
Lord,
Which order, please show us?
Lord, I don't have, Lord, I have it on my phone on WhatsApp. That's the problem, Lord. I can.
Find out. Find out if this order is there.
I
Producer,
have it.
pass it over once. Yes, next. What is this matter?
Lordship, in this matter, Mr. Parthasarathy Roy is appearing on behalf of the appellant, your lordship. On his ground, I'm only praying for not today.
Yeah, not today. Next.
But 14 and 15, my lord.
Cancel the parted. Will not be able to.
Lord, you can keep the matter, my lord.
Take down.
Good, great.
What is the issue involved?
Lord, it is a auto transfer from the, my lord, without any application.
comes in, can you transfer? Tell us, tell us, tell us.
No, my lord, here, my
Pass it
lord,
over, pass it over. Short
my lord,
point.
my lord, kindly, my lord, kindly.
Pass it over, short point.
My lord,
Next
Mr.
matter,
Banerjee is not there in town today.
Next matter,
My lord,
16, please. Yes. Not today. 17. Make it not today.
I'm appearing for the appellant, my
What
lord.
is this matter?
But this is a partition suit.
Not
But
today.
it has been referred to mediation. Your lordship will kindly extend the date of the mediation.
My lord, every formalities regarding the mediation, we were asked to submit a valuation report. They have, and we have also prepared it.
Just, my
A
lord,
mere restriction, my lord.
held.
On the
Last
joint,
order is, my lord,
on the
3rd of
joint trial of
January.
the.
We expected that the mediation will be completed within 4 weeks.
CSV says so.
Continuing for substantial period.
Next. This one, 4 weeks from the date of communication of this order. Because the matter is adjourned for 6 weeks. It's able to mention it. 4 weeks from the date of communication of this order to the learned mediator. The matter is adjourned for 6 weeks. Able to mention in the email. The matter is settled before the learned mediator in the meantime. Six weeks for that. But able to mention. Yes, 19.
19, my lord, I am for the appellant. I have also prayed for, my lord, stay of all further proceedings in my suit. I'll tell you, lordship,
Self-injunction.
Sorry?
Self-injunction.
self-injunction, for the simple reason, I will tell you, lordship, my lord, the suit was filed in 2017. Thereafter, my lord, several attempts were made. Ultimately, my lord, an ex parte decree was passed. 1.5 years after the ex parte decree was passed, the defendant came forward with an application under Order 9, Rule 13, saying that I was not served, decree be set aside. The decree was set aside. Now, against that, my lord, the appeal is there. My lord, I shall tell you, lordships, why. My lord, they admit that they were aware of the suit.
No, question is whether the summons was served upon.
I'll show you, lordships, my lord. If I get the opportunity, I'll show you, lord.
Not today, it will be hard.
No,
to
I
know.
have an application, my lord. What they have done after my the dismissal of my lord, allowing of their application under Order 9, Rule 13, they made an application under Section 5 and 8 for arbitration. Now, my lord, I want to get my appeal heard, my lord. There is a stay, my lord, of that. In my application, there was an order of stay passed, my lord, on 25th April.
Your section 5, their section 5 and 8 was stayed.
Yes, your lord.
All further proceedings in
So
this.
that you are enjoying it.
No, that was a limited order, my lord. May that continue for the time.
How long it was there?
For 8 weeks from 25th of April.
It has expired sometimes back. It has expired sometimes back. I cannot say.
Lordship, the appeal can be heard out. It's ready
No, no,
for.
but
Yes, yes.
are you opposing the prayer for extension of the time? Because your section 5 and 8 is there.
Yes, your
So
lordship. It's.
see, if Order 9, Rule 13 is allowed, then obviously the suit is restored.
Yes, your
And
lordship.
then your section 5 and 8 can be heard. If it is not allowed, then his decree stands.
Lordship, may I only suggest something subject to what falls from my lordship and my my learned senior friend. Lordship may grant a small limited time and let the matter be heard out.
My lord, in fact, we mentioned for hearing of the appeal, my lord.
Lordship, since there's been a change, your lordship,
We
The
mentioned
appeal may
for
be heard
hearing of
out.
the appeal, and that is how it is appearing in the list.
limited
Concept-
extent.
I was humbly praying if the extension could be for a shorter
The
period.
matter should retain its position.
Very, very much grateful.
20.
I am obliged.
I am hearing for the appellate.
What is matter?
Arising out of a substitution application in a section 34 proceeding. Malad, it is a partnership firm. The partnership firm interest has, the sole proprietorship's interest has devolved upon a partnership firm. There has been reconstitution of the partnership firm. Now, the state of West Bengal filed the application for substitution, wanting to implead one of the legal heirs in person up as a respondent. Now, that we had opposed, and we had indicated what is
But
the,
if the deed of partnership shows that the interest of that partner would devolve upon his legal heirs.
no, it does not. The person was a sole proprietor.
Yes.
Business was a sole proprietorship business.
Correct,
Then it became a partnership.
correct.
So, Malad, the partnership is a legal entity, registered partnership.
And
That
it will
partners-
also, it will also indicate the devolution of interest
Yes. Well, a
on
partnership.
debt. Unless it is a partnership at will or for a.
No, it is not a partnership at will. It had the named partners. Thereafter, Malad, some partners were re-inducted, some partners retired. So the entire devolution is given. Now the question is, Malad, it was never the asset of that person as on the date of his death. It was already vested in the partnership firm. So there is no question of, Malad, the right to sue surviving upon the legal heirs. None of the legal heirs can be impleaded as parties here. So I can give your lordship the entire devolution. Malad, kindly note 2-3 dates, Malad.
What does a partnership deed says
Yes,
on the,
I'll show you, lordship. The partnership
but
deed
where is the
ex-
other side? Where is the other side?
state of West Bengal, Malad.
This is the only point.
This is the only point.
We'll pass it over, let us see.
And they have never appeared. That is the difficulty, Malad.
They have never appeared.
Initially also the matter appeared before the other division bench.
Anirban Roy appeared, learned GP.
The order was that the papers in the stay petition should be treated as an informal paper book and the appeal should be heard out. Malad, kindly note two things.
Just,
Malad.
just a minute.
At the time of passing of the award, it was the sole proprietorship firm in favor of the sole proprietorship firm of the deceased. After, at that stage, application under section 34 was filed. Then also it was against the person carrying on business as the sole
So
proprietorship.
this will go to the benefit of all the legal heirs.
No, what happened,
Cannot
Malad?
form the asset of the partnership.
That is what is the partnership deed says.
No, no. How they can
The
decide,
I'll
how they can decide how.
then all the members of the all his heirs were the partners of the firm, and it was agreed that the whatever the balance to the standing to the dues of the sole proprietorship firm, that will be taken over by the partnership firm. So entire devolution was in favor of the partnership firm. Three partners, my lord, the deceased, his son, his grandson. And the partnership firm took over the asset and liability of the
was-
sole proprietorship business.
It was said that in notice, the name of Usharanjan Sarkar be deleted.
Yes, he has died.
Record- He died.
He
And
has
record the name of Obhijit and Shraddha Sarkar as partner. And the name of Sri Shubir Sarkar as son of Usharanjan. See, Usharanjan, unless Shubir had a right at the time of the death of his father to receive the amount. If Shubir is not a party to the partnership, his
He
interest,
was a party to the
no, no,
partnership.
then that was to be adjudicated.
That has been. Well, a partnership deed is on
Shubir,
record.
have you given notice to Shubir? Shubir is opposing.
Shubir has not been given any notice. Because we have given, no, because the state of West Bengal is the applicant in the,
They filed an application for substitution
therefore, applicant
on the death of
Usha Ranjan, who was the sole proprietor.
Subir was not the partner. Where is the state? Where is the partnership deed? Have you
It is on
disclosed?
record.
But where is the other side?
My lord, if I can show you,
You can get hold of Mr. Roy, we can take it, pass it over. Get hold of Mr. Roy. What's the point? Yes, next. Get hold of Mr. Roy.
Please, your lordship, I am for the appellant.
This I will not take. I mean, make it only not today. So you can go to the.
Lordship,
regular.
please.
22,
Lord, I'm for the appellant.
what is this point?
My lord, my learned friend is here. My lord, can it be passed over? My lord, my seniors.
What is this matter?
My lord, the matter is, my lord, there was an agreement between the appellant and the respondent, whereby, my lord, a plot of land in, my lord, the Vedic village was, my lord, supposed to be given to the respondent. My lord, money was paid. My lord, there were certain formalities as mentioned in the agreement. Those were to be complied, and my lord, registration had to be done.
No, what is the order under appeal?
My lord, the order under appeal gives, my lord, the respondent number C, respondent a prayer C, which is a blanket order injuncting me from operating all the bank accounts pertaining to 6 PAN cards. My lord, I have preferred the appeal against that order. My lord,
Now, what is your
my
claim?
case is, my lord, I am ready and willing to, my lord, give them the plot of land. I have the money with me. I am ready and willing to give them the plot of land. I have, in fact, filed a suit for specific performance. My lord, the writ of summons are on the way of
No,
being.
is it the matter whether contempt is pending?
No, my lord, no, my lord, that is a different matter. My lord, if your lordship passes it over, my lord, I'll request Mr.
What is
Shah.
the order? Let us see the
My lord,
order.
order is of 29th September.
My lord, there's specific admission on the part of the appellant, my lord. On top of that, my lord, there was a direction to deposit the money, my lord, to create a security, my lord. My lord, they have not. They are after taking the money, they are showing us some marshy plot of land, which is not
But I
worth
have-
the money which we have already deposited.
And I'll
My lord,
demonstrate.
we don't want anything other than our money, my lord.
My lord, not once, not twice, 3 times we have shown them different plots of land. They wanted to take. Agreement is of 2012.
But if you on 30th July 2014,
Yes, my lord.
if you have agreed to pay the principal amount with interest,
My lord, the thing is, the agreement was terminated as far back as in 2019. 2014, the agreement is termination in 2019. Here, the respondent themselves had a cold feet, my lord. They have come in late, my lord. I'm willing.
how much amount you have paid?
My lord, we have paid
72.
around 73 lakhs, my lord.
You have paid 73 lakhs.
My lord.
My lord, I'm ready and willing to give them the plot of land. Even I have a right. My lord, even I have a right. Here,
Then you fight out the right, but
my lord, may I be permitted, my lord? My lord, my senior is on his way. My lord, kindly passes it over. My lord, Mr.
My lord,
Shah
then
will
kindly
be
passes it over. My lord, all they are
kindly
showing, my
passes it
lord,
over.
my lord, we have paid them the money for a fresh plot of land instead of handing over us a villa, which they, for which the agreement was entered into. They are now showing vacant plot of land. And we don't want any land. We just want the money back, my lord.
Here, my lord, my learned friends are already secured. Lordship will have to hear out the appeal.
no, you have deposit the amount.
It is already secured, my lord. There's not a direction of deposit. The order that is imputed, my lord, directed that the bank accounts not be dealt with without keeping apart the money claimed. And my lord, restrained from certain shares being dealt with. That is being complied with. There is no further direction today.
No. He's saying your advocate on record was saying that this matter can be disposed of if they agree to a plot of land.
That is correct. Several attempts have been made at that, my lord, but to no fruition. Because, my lord, our case is that we have all along been ready and willing to convey the land. And, my lord, aside from the plot that was indicated, my lord, different plots have also been offered. My lord, the direction impugned was that the bank accounts not be dealt with without keeping apart the amount claimed. That is complied with. Lordship will kindly hear out the appeal on any convenient date.
My lord, we have already filed an application, my lord, GA2, my lord. My lord, they have not complied with the order. My lord, let them show any document, let them disclose any document that, showing that they have complied with the order.
Kindly allow me
show
to
the
file an affidavit in
bank
that,
statement.
in that application, in my learned friend's application. There is no direction to file affidavit yet. Allow me to use an affidavit kindly. My lord, there is also an order of the division bench of April 2022, my lord, recording that the appeal can be disposed of on the basis of the documents already on record. Kindly hear of the appeal.
No, this security may continue till the disposal of the suit. What is why you, because the nature of the order is such that you have to secure this amount. You show your bona fide. After all, you have to show your
It is
bona fide.
already, my lord, the bank accounts are, my lord, I am restrained from dealing with the bank accounts.
You secure the amount of 70 lakhs. That is the precise order. You secure this amount, the suit may be expedited.
My lord, that will amount to, my lord, additional relief being granted over and above what is the direction in the
So
impugned
you
order.
think, as it is, your amount is being, I think that has.
May I request your lordship to use the microphone, my lord? I'm not able to hear
Yes,
properly.
this microphone is there.
Sorry.
No, we are saying that prayer C, what does the prayer C says?
My lord, in the application, the petition that was filed before the first court is at page 25. Your lordship will find the prayers at page 32. Prayer C was, my lord, order of injunction be passed, restraining the respondents from dealing with and or disposing of and or alienating and or transferring and or encumbering their assets and properties and from withdrawing any amounts from their bank accounts and particularly those mentioned in paragraphs 19 and 20 herein of without keeping apart a sum of 2 crore 30 lakhs. That is done. Well, no, there is no separate direction for me to deposit with either the court or my friends.
That if this order continues till the, see, you are saying that it might affect your banking transaction.
My lord, I have prayed for a stay of this order that has been refused. So I am only praying that the appeal be finally heard out, nothing more.
Instead of having, because this order, in any event, if it continues, it is continuing for some time.
My lord,
If it continues to the disposal of the suit, nothing is going to, we may change it to you furnishing a bank guarantee to that effect.
let me take instruction on that in that case, my lord, kindly.
Furnish a bank guarantee to the effect of, to the credit of the suit for this amount. Then we may vacate this order and,
May I take instruction and come back in that
if
case?
they
my lord?
furnish your bank guarantee, it is good enough.
My lord, if they, my lord, in terms of the paragraph number
They give
22
you
of
bank
the,
guarantee for 72.50 lakhs.
That is the principal claim, yes.
my lord, that's a principal amount, my lord. My
Yes.
lord, the order was for 2 crore 30 lakhs, my lord. My lord, if my lord kindly takes
So,
a page,
see,
page number.
question is this. 2 crore 30 lakhs is based on the interest at the rate of 18%.
My lord.
Question is, interest is always a discretionary relief.
Lordship.
They have filed a suit, whatever the outcome of that, God knows. But this amount, you are entitled to security, 72.50. So this amount, if they furnish a bank guarantee, because you see, you will not be able to keep a watch on whether they are really withdrawing this amount of always uncertainty would continue. So if they give an unconditional bank guarantee in favor of the Registrar General and shall keep it renewed till the disposal of the suit, and the renewal should be made 15 days prior to its expiry, failing which it shall be immediately invocable. You are saved.
My lord, we have paid them the money in 2014. My lord, the agreement was.
True, but that interest portion has to be decided in the suit. Once we are securing the claim, the securing the claim is first is a principle. Interest element would come on, it may be, if it is a deliberate, if they may have some explanation, you may have some explanation, but interest normally is not taken into consideration. So this amount can, this is one way of looking at it. Or if they create a fixed deposit of 72.50, that will also do. If they create a fixed deposit, better you create a fixed deposit for this.
I can take instruction on that also, my lord. These are all
You mean they create a fixed deposit for this, it will earn an interest by the time the suit is heard. So you are getting interest from maybe from the date of creation of the fixed deposit. And for the interim period, if the court decides on the quantum, how much is, suppose you should.
My lord, this quantum has been admitted.
no. How is this quantum admitted, my lord? I join issue there.
It's not a question of, is the order was in the nature of injunction. It's not a judgment upon admission.
Lordship.
You have not got a judgment about admission.
Order 30 rule 5.
So it is on principle of order 39, basically, 1C.
Lordship.
Order 39, 1C. But the nature of the order that we are going to pass will be more beneficial to you. Because if we create fixed deposit for this amount,
My lord.
now the interest rate has gone up. So whatever interest will accrue to this, now if you ultimately succeed, then the court will quantify the amount of interest you are entitled to. And to that effect, because this amount will be secured for you. This amount will be secure. This amount will be secured for you.
Agreement. My lord, in one of the subsequent agreement, my lord, which was entered into between the parties in 2016, they have admitted, my lord, they will be paying interest
See,
if
this
the
amount is not going to your hand in any event.
Again, well,
But if it is in
my
the,
lord, let it be secured then, my lord.
that
that
is
is
why
what the court is
that is why
suggesting.
say the fixed deposit amount was 72,150 should be clear. That is the principal amount
My lord.
in a fixed deposit account. The original fixed deposit receipt shall be with the registered original side.
My lord.
It shall be with the registered original side and shall be renewed till the disposal of the suit. In the event you succeed, this amount will be automatically payable to you. Will provide that if a decree is passed in your favor, this amount will be Registrar General shall immediately encash it and pay the amount to you. For the balance, you may have to execute. That's a different issue.
My lord, I can take instruction on your lordship's suggestion, my lord. However, without prejudice to that, my contention has always been, my lord, that the requirements of Order 30 Rule 5 have not been satisfied. For the asking, it has been granted.
39 once is good enough. And the facts are such that we may not.
I do appreciate, yes, what the facts are. They have been out of pocket. It is true, my lord. But there is no allegation that I'm dealing with my assets, etc.,
That
to
is a
deprive
question of
them.
allegation. If they are out of pocket and that on 30th July 2014 you agreed to refund them, then this is all the more required that you should secure it.
Lordship,
That security is there.
lordship.
Instead of having this kind of a order, what we suggest is
I appreciate completely what is following from your lordship. Yes.
I will not go by bank guarantee. You will not go by bank guarantee. You deposit create a fixed deposit account, and it's the original fixed deposit receipt will be with the registrar.
Lordship, kindly allow me to take instruction on this.
What do you say? Are you agreeable to it?
My lord, I need instruction regarding the fixed deposit, my lord. My lord, kindly passes it over for some time, my lord.
Coordinate bench had observed
My lord, kindly keep it for another day. Let me take instruction. We will come back to your lordship.
My lord, though, my lord, initially, my lord, though
You are not realizing what we are saying. A
My lord,
bird in hand is always better than two in the bush. You are getting the exact amount being deposited with the registrar. This
will
order
not
does not
interest.
secure that. It has not, it is intangible. So for today's concern, it is intangible. It's an intangible thing.
Nah,
Principal,
72.
You get the cash amount.
Entire cash amount.
interest type.
Allow us, my lord, to take instruction and come back. Kindly.
My lord,
Both parties.
Today itself,
My lord,
Lordship,
today may
my
be
lord.
half an
difficult.
hour.
No, my lord, kindly keep it tomorrow then, my lord. Because my instruction is to pursue the appeal and to not, my lord,
Only for this limited purpose
give any
tomorrow.
concession.
Tomorrow, part of tomorrow.
Grateful.
Only for this purpose.
Much obliged, my lord.
Grateful.
Part of tomorrow.
Your lordship's pleasure to pass an order, my lord.
No, we have
Should be
part
keeping
of
it
tomorrow.
tomorrow.
Part of, we said
My lord, my lord, my lord.
part of. Oh, the hard in part tomorrow.
I'm grateful.
I'm grateful.
Yes, yes.
I appear for the appeal. I appear for the appellant, my lord.
What is this matter?
But this is a matter, my lord, pertaining to my lord, Suomoto transfer of my lord, the
Yes,
winding up
yes,
petition, my lord. I am my lord, the petitioning creator before the court below.
At what stage?
My lord, here, my lord, the property has been sold. Even 2 status report was filed by the official liquidator indicating the property was sold. And my lord, this application was filed.
Who are you? Who are you?
My lord, I am the petitioning creator before in the company petition, my lord.
Who is the official liquidator?
Smita Das, they was
Yes, she was here. Pass it over once. Pass it over once.
my lord, kindly take it up at 2 p.m. then.
No, pass it over. Yes.
My lord,
Yes, Mr. Ghosh, what is the
Yes.
matter?
this is an appeal by one of the original plaintiff in the suit died. my lord, he was in the capacity of an interim board member of the company. He was
Appeal
there.
has to be heard there.
Yes.
Today will not be able, so we'll make it not today.
Then your lordship will let it go out because I'm trying, I won't succeed, the Oja brothers, but I'm trying, my lord. Now there's one left. After 9 of them have passed away, one is left.
That lockers.
Yes, the calculator safe deposit. So my lord, this is a technical appeal in the sense that before when the
Please tell us what to do.
lordship, the last time's order was it was deferred for some time.
Yeah, make it not today because tomorrow we'll have a new bench.
Yes.
So there you make your prayer, it will be done.
Then your lordship will make it not this week. Then we'll
not
try
this
and come with a solution.
Not this week.
I'm grateful.
25. Yes,
May I please, Lordship?
yes.
This is the matter, my lord, relating to the company's, my lord, the Soumen to transfer of the application from this High Court to the. No, this is a company petition, my lord, which I had submitted earlier when it came up, that this was not at, this was a pre-admission stage where no notice was served on 26 and it was to be compulsory transferred and either it will be abate.
But have you served?
I have served and I have given another hearing. My lord has passed an order on 21st June. Thereafter, I have served another notice to my other side. My lord has fixed a bunch of few other matters also, which were item of 14, 15 today, I understand, in the list, where the court was considering this, whether this court can sue a to transfer without any application to the NCLT. But I have some additional point also in the matter.
No, in view of the aforesaid, CP stand transferred to National Company Law Tribunal.
Yes, my lord.
So this is the order.
This is the order, my lord.
You're challenging this order.
I'm challenging this order.
Why?
But I'm challenging this order because, my lord, this winding up application was filed in 2016.
Yes.
And it was an application where no notice under 26 was served.
So that it was transferred.
And that I had said shown to your lordship, my lord, in that in the notification of the transfer, that if it is not transferred, it is automatically transferred. And if the proper application steps are not being taken, then the proceeding will abate. And they will be entitled to file a fresh application after in the NCLT. So this is a petition which has stood abated. My lord had seen the notification at page 42 of the petition of this page 42.
Yes.
Well, this is 2017, my lord. But these rules may be called Companies Transfer of Pending Proceedings Second Amendment Rules 2017. If my lord, we kindly come to this paragraph 5. Transfer of pending proceedings of winding up on the ground of inability to pay debts. All petitions relating to winding up of a proceeding under clause A of section 433 of the Act on the ground of inability to pay its debt pending before a high court and wherein the petition has not been served on the respondent under Rule 26 of the Company Code Rules 1959 shall be transferred to the bench of the tribunal established under subsection 4 and 490 Companies Act, exercising territorial jurisdiction to deal with in accordance with the part 2 of the code, provided that petitioner shall submit all informations other than information forming part of the record transferred in accordance with Rule 7 required for admission of the petition under 7, 8 or 9 of the code, as the case may be, including details of the proposed insolvency professional to the tribunal up to 15th July 2017, failing which petition shall stand abated. This was an extended time. Earlier it was June, 60 days. provided further that any
The
party or
learned judge has
parties to the proceeding
The learned
shall,
judge has transferred it.
my lord,
The learned judge has transferred it.
my lord, this proceeding has abated. And they were given entitlement to file a fresh application before NCLT. My lord, we can see the second proviso.
See, the judgment of the Supreme Court is quite clear on this.
My lord,
Judgment of the Supreme Court is quite clear on this.
yes, my lord, judgment of Supreme,
Says that where no notice has been served,
yes.
the CP should be transferred to the company law.
No, my judgment is this. The judgment is those which were compulsory transferable.
If a winding up petition is filed
Yes, my lord.
and if it is at the notice stage,
It is,
if it is at the notice stage,
yes.
not served, it will automatically go to the tribunal.
And it says that if they are to required to file the proceedings there, if they don't do it, then it stands abated.
That's a different issue.
But
The question is this, he is proceeding when he files it,
yes,
by reason of the judgment of the Supreme Court, it has to go at that stage, the stage where you are for the petition creator.
Yes, no, ma'am. Yes, petition creator, respondent here.
Yes. So the stage where she was, from that stage, it will stand transferred to the company law board tribe.
but just at that juncture, my lord, the two positions come up. That the transfer says that those rule statute says it will stand abated, and an abated proceeding court does not have jurisdiction which the court has held in the order. My lord, we kindly see the order. The order says that this court has no jurisdiction, my lord, because proceedings has abated. When the proceedings have abated and no jurisdiction, then question of transfer won't arise.
Where do you find abated? Where do you find abated?
Abated, my lord, kindly see page 43.
Can the rules?
Provided, my lord, this is statute.
No, this is a rule.
But this is, my lord, kindly see, this is under the, this excessive power conferred 1 into 434 of the Companies Act read with
On transfer
code.
of proceeding 2016 rules.
Rules, my lord.
Yes.
This transfer rules were by the operation of the statute.
There is no question of abatement. Where do you find abated?
Abatement is there. My lord, can you see first proviso?
Yes.
Provided that, if my lord has got it, rule for provided that
The petitioner
just
shall
submit all informations other than informations forming part of the record transferred in accordance with Rule 7 required for admission of the petition 7, 8 or 9 of the code as the case may be, including details of
Yeah,
the
yes,
proposed insolvency
Anything
provision
else?
up to
Anything-
15th
anything
July.
else? Anything else?
Failing with petition is still abated.
Anything else?
What I'm submitting is this thing. This is the one point. And number 2 point is this, that when the statute says as to the transfer that it has to be on the basis of an application, then this court has held whether this power can be exercised sua motu or not. This is what the division bench, coordinate bench has passed an order, which your lordship have kept it item number 14 and 15
We'll
was
dispose
the
it of
matter.
here and now.
My lord.
We'll dispose it of here and now. Yes.
My lord. So there here says
You
that
must, how much is the amount they have claimed from
well,
you?
this is amount is about 10 lakh of rupees, which is not tenable. 2016 and paragraph. Well, may I say one thing? My lord, when I say this, that this point which I am taking for this, because in a petition which is being filed, I am entitled to take my objections to it. Let this point of abatement remains open and I can put up.
Take out.
Yes.
Moved the application. We told the honorable judge that we'll take out an application provided this is restored. He comes up and says, there is nothing in this application. All matters are being transferred. Kindly have it transferred. It was only on this ground. Restoration and transfer was made by the same order. My lord will
Not
Mr.
there in the
Banerjee had
order.
agreed that, my lord will
No,
kindly
where is
see
that?
where Mr. Banerjee had agreed that the matter should be transferred. It was never our submission at all.
আমার এখানে একটা বই নেই compressor।
I want to see the
On
rules.
this ground itself, my lord, the other bench did not agree to admit the appeal.
একটা rules টা আছে। Rules টা আছে একটা। The rules judge.
Wait, 56. 56.
We'll pass our order.
Two.
We'll pass our order. अपने यहाँ पर चला के दिया रहो.
Is not by consent. Order says clearly, page 46. By consent of the parties, winding up is taken up for hearing. It is not that I have consented to this.
This is not
nothing.
there. The advocate came
What-
up and
or-
made that submission.
So,
Yes, next, madam.
so my submission is this point of mine.
Very well, very well. Shall see. You have a very poor case on merits, we understand. Yes. Pass one minute. এটা হয়ে গেছে অর্ডারটা দিয়ে দেবো next matter please all the passover matters where is Mr. Roy?
No, this is another matter. This is
Acha,
the
who is-
ex-party decree.
But why this is with regard to your
Suit was transferred to the commercial division.
oh Mr.
They've done-
Bachwat said it is covered by
Yes, your lordship's judgment.
My lord, item number 12, I'm praying for a not today.
what is the judgment?
Yes,
Judgment. You are appealing for whom?
That was an appeal from a dismissal of the suit for non-prosecution. That was also a suit under the commercial division. But the plaint and the amendments, necessary steps in terms of the commercial division were not taken. Kindly come to Malad. Kindly come from page 4, top.
No, this is a commercial suit.
Yes.
My lord,
Your
I'm praying
lordship's
for
order is
not
there.
today, my lord.
No, this is a commercial suit.
Commercial suit.
Who is appearing?
The Shoroshi's Dashgupta.
Well, I
Because
just,
here,
well, it is a division bench order whereby the suit was transferred to the commercial division.
no, here the case is this. There's a slight distinction between the two. Here, the learned judge was also exercising his jurisdiction under the Commercial Courts Act.
Yes, but
Here the decision was, it was slightly different. Here, the question in your case, the question was Order 9, Rule 13.
yes, Order 9, Rule 13.
Yes, Order 9, Rule 13 has nothing to do with whether he was deciding in the commercial or non-commercial.
No, one point, my lord, your lordship will kindly
So
consider.
which will not help you on this.
No, I'll show your lordship, my lord. If your
It
lordship,
will fall under Order 9, Rule 13. Because if the situation is like this, that as on that day,
after the
on that date, he was not having the determination of commercial court.
no,
The situation would have been different. If he was not having the determination of commercial court, what you are saying is absolutely correct.
no, but here the decree has been passed in original jurisdiction.
This is not because maybe, but that was it can always be corrected. That's a different issue.
It's a question of inherent
it's
lack
a-
of jurisdiction.
Because it's a while he was deciding, he was wearing two hats.
Yes, maybe,
He was wearing two hats.
but
But it is not that he was not having the determination of that jurisdiction also. So if it's a commercial, then it is all the more bad for you.
no, but may I submit what I would like to say? Kindly see, on a particular date, the suit is transferred to commercial division by the order of the division bench. Thereafter, we have given them a notice to inform us the suit registration as per your lordship's division bench
Not
order.
required, not required.
No,
Then
therefore,
then whoever is your solicitor, he must surrender his membership with the incumbent law society.
but question is, my lord, the
Whatever the question, then he's not, we will recommend that his
Probably,
his
but,
license be cancelled as a solicitor.
maybe I have,
Doesn't know.
but even if I have given a that kind of a letter, but the question is, the plaintiff
You have
must.
you have knowledge. You are delaying the thing. Is absolutely clear on this.
No, my lord, your lordship will.
Is absolutely clear on this.
Let us go into the facts, my lord. Your lordship will kindly
No,
allow.
it's a question of you, after you having the notice of the suit being marked as a commercial cause, you did not take any steps. How much is the amount due?
What the amount due was, sir? 90,000. 90 lakhs.
85 lakhs is the principal amount.
No, decretal amount,
90 lakhs.
1 crore, my lord.
1 crore. Have you deposited the amount of 1 crore?
But I am willing to deposit. my lord. Well,
You take instruction.
I will contest the suit. my lord.
Just a minute. You take instruction, 1 crore, you will deposit, which will be in a fixed deposit account, not a bank guarantee, cash deposit. It will be in a interest bearing account and will continue, will direct them to file the written statement upon payment of 1 lakh to you as cost. 1 lakh as cost to you, and will give them 2 weeks time to file his written statement. If he doesn't file, the decree will be immediately implemented. Is your client inclined to accept this order?
Okay, I'll take instruction.
They will deposit 1 crore in cash and 1 lakh to you
As cost.
as cost. Very well. So this case will not help you any events.
Well, I would have liked to argue, my lord, on this point, because your lordship sees only one thing. Even after it is whatever
What is very clear, Mr. Sen.
No, but I must have the
No,
commercial suit
No,
plaint must
yes,
be there.
absolutely. We appreciate your anxiety, Mr. Sen.
Not a question.
Extreme anxiety manifested in all forms,
It is
in
not a-
all hue and color.
It's not a question of anxiety, my lord. What I was
Very,
trying.
yes, absolutely. Well, you are so anxious to defend yourself. You have such an impeachable claim.
Yes, that I have. That I have. Well,
Deposit, you show it. You have lost 1 crore, you deposit in cash, 1 lakh to them in cost, and then it will be hard as a commercial suit. We shall see to it. Only for this limited purpose. You take instruction. Tomorrow, part heard. আমার এসছে ওগুলো আসেনি না Yes, for the list. Yes.
Led by Mr. Banerjee, Milad.
It's an application by the
The Suomoto transfer of Milad the company petition.
At what stage it was transferred?
Milad after the admission, Milad and Milad the well was in the custody. Milad they were Milad taking steps for sale of the
Sale
sum
is
of the
pending. Sale is pending.
Sale is
Valuation reports filed.
that stage, Milad.
If the sale is pending, it
Yes.
can be transferred.
Milad,
If the sale
kindly
is
Milad.
pending, it can be
I
transferred.
appreciate Milad. Kindly
That is
get
a-
it done, Milad. Kindly Milad.
Decision of the Supreme Court.
No, Milad. We'll try to differentiate that.
No,
Milad.
differentiation is nothing.
Yes.
3 stages
Factually,
indicated.
right. Milad,
So sale
factually.
has not taken place for last several years. From 2019, the sale had not taken place.
Milad, 2021, 22,
Sale had
Milad,
not taken
2020 and 22 we have lost
But
in
for the
Milad in
petition is
COVID.
later. You have
No,
to-
no, 2019, the winding up order was
Order was
passed.
passed.
And then
then
because of the
2020,
pandemic issue,
no,
your
sale
lordship
was-
couldn't take
Only one
steps.
prayer. Milad, only one prayer. Milad, kindly pass.
The secret credit, I am paying a lordship, may grant us leave to file a short note.
Short note. Why?
For the we are not a party.
No, you are a secret creator.
Yes.
Then what is you want transfer or not? What is your view on this? Please, Mr. Sil, please.
আসুন না এই নিন।
What is to? Motor beta is to. That
We have not received the copy of the paper book, my lord.
no, it's a very short point. The point is very short. The judgment of Justice Kapoor directing transfer, he has relied upon two decisions.
Yes.
The Supreme Court in that decision has categorized the cases where it has to be transferred. So one category was that where petition has been filed, no notice served. Second stage petition filed, admission is there, but no adjudication. Third is that even if there is an adjudication, but no sale had taken place. So here you come within in the third limb, where winding up may be there, but no sale had taken place. It is being argued that it was not being sent at the instance of the petitioning creditor.
Yes.
But whether that itself takes away the discretion of the court, because the company is in liquidation now, the well is in custody of the matter. You are a secure creditor. You are a petitioning creditor. So according to them, the petitioning creditor, unless the petitioning creditor files an application, the company petition cannot be transferred. That is the only issue. So tell us what is the point. What is you have to say on this?
Milad, I'm led by Mr. Banerjee. Milad, kindly Milad, allow me to come up wide Milad to Milad, get the matter Milad dismissed in Milad on our shoulders. Milad,
Matter was fixed that
Milad, yes, Milad, we have given the law notes Milad, person to Milad's direction.
What is the law notes? Yes, we'll consider the
We have filed. But Milad, kindly Milad gives us any day, Milad, tomorrow, Mr. Banerjee will be there.
At what stage it should be transferred to the NCLT? This is also an issue, Your Lordship, because already 434 2C is the fifth proviso. First of all, there should be an application, but I should not open my mouth because I am for the official liquidator.
We can
But
come tomorrow, Milad.
it's a settled law in that sense at what the binding of order was
when
passed.
company went to liquidation.
2019, 4th November 2019.
2019.
After pandemic event.
When did you invite claims?
Claims were invited, my lord.
You give us a
Yes, we have already filed one status report. May I hand up a copy of my status report, my lord? Because all the claims were received 2020, Your Lordship.
What is the status report?
2020, my lord. And 21, Your Lordship, we obtained the order for the valuation of the assets.
What is the status report?
May I hand up a copy of mine, my lord, for the timing? A file হয়েছে তো। Judicial folder এ থাকবে। Oh, this is this is 14 going on. So why were you sitting there?
I do not know your genius.
14 and 15 together. I'm in 15, she's in 14.
Oh yes, what is the status report? Have you filed the status report?
No, Lordship, in this matter, I have not filed, but I have one short status report. If your Lordships kindly give me bonded time so that I can prepare status report and file it.
And in
On the next
respect
date,
of
Lordship.
15, my status report is with me.
You have 2 copies for us.
This is my copy. I was handing up. সব ফাইল করা ছিল ট্রায়াল করতে হবে আপনাদের কাছে আছে দেখুন
না আপনি দেননি
Yes, madam.
You are appearing for
UCO Bank, they're the secured creditor, madam, the lead bank. We have the lead bank. We have the lead bank.
Number 14, there are several secured creditors.
Mr. Molloy Shul, land advocate. make time according to our decision.
Kindly, Milad. Well, he's not there, Milad. Milad, kindly, Milad, Monday.
Then the court has to fix time according to his convenience.
Milad, Wednesday.
No, court has to fix time
No,
according
no,
to his convenience.
Kindly, Milad.
So let us fix our time, please.
Milad, kindly, Milad, keeps it on Thursday, Milad. Kindly, Milad.
Don't make a submission. It is the court's time. It's not a council's convenience.
Absolutely.
Then why you make this submission?
No, I am also not.
Since when the High Court is started functioning according to the convenience of the council?
Milad, we used to indicate to your lordship, Milad.
Never make this submission. It's the court's time. It is not the council time. Today we fix it. Mr. Banerjee knows that the matter is fixed today. Then why he has taken a assignment elsewhere? The matter is fixed. We are fixing this matter to the knowledge of the council. Then why the council should leave one matter and go doing other matter? It is fixed to the knowledge of everyone. You are embarrassing yourself. You are embarrassing the court. बोलो report.
Yes, Lordship, by Thursday.
My status report is resolved. I'll make
No,
two
but have a
copies.
look at it. If you want to include anything, you
Within 2 to 3 days, my lord.
Wow,
I'm
please.
grateful, Milad. So grateful. Deeply. So grateful.
14, 15
14
action.
and 15 same, but the only I'm appearing for the 15.
Miss Jenny Mitra and Miss Smita Das. Appearing on behalf of the official regulator in APO 12 of 2013 and APO 35 of 2013. APO 35 of 2023. আগেরটা APO 12 of 2023 আর পরেরটা APO 35 of 2023. Status report.
Grateful, Milad.
দুটোতে
Grateful.
এটা পাঠিয়ে দেবে। কি ও আনতে গিয়ে কোথায় চলে গেল? আনতে চলে গেল কোথাও কি? কি অবস্থা অরিজিনাল সাইট?
Yes, in this
Why you
matter,
made a substitution of that person? How he's
may I just tell you, I'm not there in the matter. I was just merely acting as a proxy. Mr. Rupak Ghosh and Mr. Barun Kothari were the councils were assisting Mr. the Dalat Government. In the new list, they are no more there. Kindly gives us 1 week time, by which time these councils will be engaged and they can make the submission.
This is the only point.
This is the only point.
What at next Tuesday?
Abatement, first point is abatement.
May I take this
I have
opportunity?
said that they were already served with the notice that this partnership firm has been constituted, partnership firm has been reconstituted way back.
So abatement is the only point.
And second point is, even if his abatement is set aside on exercise of discretion, then even on merit, this Shubir Sarkar cannot come in. Substitution has to be there. It has to be in favor of the partnership firm.
No, but have you served Mr. Shubir Sarkar?
That's not my application. I am saying, well,
You have served upon Mr. Shubhi Sharkar.
That I need to take in instruction, whether it has been served.
well,
Because my understanding is,
that is what we opposed.
Shubhi
no,
Sharkar.
he had opposed that.
Shubhi Sharkar is the legal heir.
Yes,
No, but
yes, yes.
kindly
yes.
Shubhi Sharkar is a legal heir.
on the date when succession opened.
Succession opened, Shubhi Sharkar was a party.
No, my lord.
Yes, he succeeded.
No, that is the thing.
How it could be?
Well, I'll
Because-
tell you, but kindly take the
Sen,
date.
Once he died, that it was a sole proprietorship.
But before that, it already became a partnership during his lifetime.
Now, if he made a life during his lifetime, he made a partnership.
Yes, and
Partnership. Where his interest would go as a partner.
his entire partnership.
His interest where he'll go, it cannot
It is
evaporate.
I am not claiming this is not a claim for a separate property. It is this
Yes, you are
business.
appearing, Mr. Sinha.
Yes.
This business, kindly take the partnership deed once. Business has been taken over by this partnership firm with all assets and liabilities. It is only the devolution of the business, not his estate. Kindly see, well, that is the difference.
But so far as his right to receive the awarded amount to the extent of his father's share, that remains. That is why he may be brought for the purpose of convenience. Nothing for
May I just show your lordship one portion of the deed? Your lordship will be clear to your lordship.
A partnership was formed during the lifetime of their father.
Yes.
Their father.
Yes.
Where's the partnership deed
Kindly see, well, page 69 once. 66 it starts.
Usha
Ranjan Sarkar is
it
the
is recorded that Usha Ranjan Sarkar died intestate when this was a proprietorship concern.
Where your lordship?
Yes, it is stated in the judgment itself.
No, but that is the date is wrong.
No.
She died. He died on long thereafter. He died on 20th March 2020.
Just a minute.
Page 51 is the death certificate.
Usha Ranjan Sarkar. Initially, the business of Neobil was a proprietorship firm.
Yes.
And subsequently, it was converted to partnership firm.
Yes.
Shubhi Sarkar is the son of Usha. As per existing partnership deed, Obhijit and Shraddha Sarkar are the partners of Neobil.
Yes.
And thus, for proper adjudication of the arbitration proceeding, Shubhi Sarkar as well as both the partners. Now, this works contract, Mr. Sinha, is with the partnership firm.
No, sole proprietorship firm. Sole proprietor.
And so this contract was with the sole proprietorship.
With the sole proprietor.
Kindly come to the partnership deed, it is very important. Kindly come to 69. Kindly note the date of the constitution, 1st November 2013.
No, but after this reconstitution, did the government change it and give it to the partnership firm, or it continued as the sole proprietorship business of the
award was passed in favor of the sole proprietorship?
So at that time the partnership was existing?
Yes.
That time the partnership was existing?
No, that time it was not existing. Kindly see the date, 2nd March 2011 is
if the partnership was not existing, you are self-defeating argument you are making.
Because they did not inform the arbitral tribunal.
But kindly see the date. First is 2nd March 2011 is the award.
Forget about the 2nd March. Contract is between the government, state of West Bengal, and the sole proprietorship firm.
All benefits of the contract have come to the partnership firm.
Listen to us. Sole proprietorship was for the, so as the government is concerned, government doesn't know anyone else as a sole proprietorship firm. At the time of passing of the award, it was passed against the sole proprietorship firm.
In favor of the sole
In favor of sole and that time Mr. Sarkar was alive.
Yes. Yes.
This become executable by the sole proprietorship firm against the government.
Yes.
Now, according to you, this partnership firm was found prior to the award. Prior to the award?
No, not prior to the award. 2013.
Yes, prior to the award.
2013. Award is 2011.
2015.
Yes.
After the award.
2011 is the award.
2015 award.
No.
Award is 2015.
No.
2011.
Oh, that is
no. That is you. No, he's talking about another. No.
2011 is the award.
Yes.
And the partnership firm is
2013.
Yes.
And the clause says.
So as on the date of the award, the beneficiary is the
proprietorship firm.
Proprietorship, that means the person.
Yes.
And in his absence, all his legal heirs. So in 2013, when the partnership firm was formed, it leaves one of the son.
No, all the sons are partners.
Shubir is there.
Yes, Shubir is there.
So Shubir is there.
Yes. And they say that the partnership firm has taken over all assets of the sole
Which clause?
proprietor.
Which clause?
Kindly come to 69. Page 69.
So which clause?
Third paragraph. After the name, my lord, Usha Ranjan Sarkar, Shubir Sarkar, and Abhijit Sarkar are the three partners. Kindly see the second paragraph thereafter. Whereas the party of the first part has prepared its balance sheet and profit and loss account up to 31st October 2013.
Party of the first part. Who is the party of the first part?
Usha Ranjan.
So Usha Ranjan.
Lordship has got 69.
Yes, yes.
Kindly see, Usha Ranjan Sarkar is the party of the first part. Shubir Sarkar, party of the second part. Abhijit Sarkar, party of the third part. Then, my lord, whereas the party of
But who was left out?
these are the two sons who had come in.
No, but substitution for whom, Mr. Sinha?
Usha Ranjan.
No. Substitution, Lord, for
Ranjan.
Shubir Sarkar.
They want to bring in Shubir.
No. Shubir is one of the sons.
Yes.
Now he is not there in the partnership.
He is second party.
He's the second party. Then
He is the second party.
why you require him to be brought on record?
This has been reconstituted thereafter. Shubir has gone out with his share. All the deeds are on record. But the first partnership shows that the partnership has taken over all assets and liabilities of the sole proprietorship firm as at 31st of October. So the benefit of the sole proprietorship has gone to the partnership with all liabilities. That is the paragraph, my lord. Whereas party of the first part has prepared its balance sheet, profit and loss up to 31st October in respect of its sole proprietorship business, it is the desire of the part.
My lord.
If the partnership firm had taken over the entire assets, you are not concerned with who is there. So after this recital, this was a partnership of Usha Ranjan and his two sons. So the partnership has to be.
My lord, today, my lord, I'm not 100% prepared. I'll need a day's time, Lord, because the councils were appearing, Lord, they are no longer in the panel. I'll have to make some changes. But no, the other thing, Lord, before going to the merits, Lord, the issue of maintainability had arisen before the previous bench, and they were required to satisfy because this is an appeal under the Arbitration Act, Lord, not provided under Section 37. So this is not an appealable order by itself. So that will be the first hurdle, my lord friend, will have to cross, Lord, before addressing your lordship on the merits.
No, merits is your
Lord,
merits is with regard to the inclusion of
Yes.
Shubir.
Yes.
Shubir.
Yes, my lord.
You filed an application
So,
for.
my lord, we wanted all the legal heirs to be heard, my lord, before, my lord, because we didn't want, my lord, someone to come and tell us, my lord, that you excluded us. My lord, we wanted everybody to be there. Thereafter, my lord, they can decide who takes, my lord, if the award is ultimately upheld, no, then decides.
But if the document itself shows that the partnership firm has taken over, then that has taken over.
Lord,
You can at the highest, Mr. Sinha,
my lord.
all that can be done and notice can be served upon Shubir.
No, that is what our prayer was. Lord. That is, I think, Lord, they don't want.
No, Shubir is not a third party.
Not a third.
Shubir is a son.
He has left
Shubir is
the
a son.
partnership. He has left the partnership.
By
firm.
when he has left the partnership.
I'll show you, Lordship. This is the first deed. Thereafter, the second reconstitution which took place. Lordship will kindly come. Kindly come to page 77. This is the deed of retirement of 15th of February 2017 between Shubir Sarkar of the first part, Usha Ranjan Sarkar and Abhijit Sarkar.
No, they want to be doubly sure that in view of this, suppose Shubir comes and frowns upon
How
them.
can Shubir come against them? Shubir may have a claim against the partnership firm.
They say that once this has come to their knowledge, so that is why they say that
No,
Shubir.
but they say by way of abundant caution, I have placed on record the actual facts before the court. Now the court will clear all doubt which he has in his mind. He is now no longer under any apprehension.
But in view of such reconstituted partnership, then becomes.
It is the principle of order.
This is not an appeal under the under Section 37. This will be any interlocutory order passed therein must be an appealable in that sense of the term. Because this is an adjudication under Order 22 Rule 4.
Yes.
Lordship.
It's an adjudication under Order 22 Rule 4.
My lord.
So this becomes an appealable order as such. It's not an appeal, strictly speaking, arising out of the
37.
Arbitration and Conciliation Act. It is an
But-
appeal passed in
but-
a miscellaneous application
It is under the.
because you see substitution, amendment, these are all under CPC.
Absolutely, absolutely.
So suppose he filed an application for setting aside and make an application for amendment. That has to be considered under Order 6 Rule 70, not under the Arbitration and Conciliation Act. So this order is appealable.
But if your lordship holds that not, in fact, it will help us in other matters. Not maybe this matter it may not help, but in other matters it will definitely help us. Lordship not takes it not day after tomorrow, but we will come back and not.
No, but if it requires such a hearing, then of course because we are not having.
I don't think it will require a very real. Lordship keeps it not day after tomorrow, not we'll come back to lordship.
Because we are releasing most of the matters, so we thought that is a small point involved. That's
It was in fact a small point.
because they have disclosed a partnership, reconstituted
Lord,
partnership.
Several deeds are there, one after the other.
Lord, in fact, there's a residual share. Lord, if lordship just keeps it not just not after that.
It says that the entire asset has been taken over. This award is an asset in the books of the.
I'll show Lord with the flow chart, not how it has how the interest not travels.
How can it, Lord, this page 69 is conclusive.
We will part at Thursday.
কবে রাখলেন?
Thursday.
Thursday. Very good.
Well, Thursday afternoon, I am some difficulty. Can it be on Friday?
First. Grateful to you.
Yes, next. What is this?
Lordship, in this matter, I am appearing on behalf of the official liquidator.
This white has come.
Status report has been filed, Lordship.
This is a suo motu transfer, Milord. Despite there being two status report filed by the official record before the Milord, the Honorable Single Bench, Milord, where Milord, the initially an application was taken out by the official liquid
status report.
Lordship,
I have annexed, Milord, two status report filed before the court below, Milord. That is the first status report. Is 38.
And second status report is at page 45, Lordship. Everything has been completed, Lordship. We have filed a summons for directions for declaring the dividend. Assets sold, claim invited, adjudicated the claim, last stage, Lordship. And money is lying with us.
Landlord. What happened that there is a irreversible situation. Everything is solution is in the
That's what you said.
Milord, there are two situations, Milord. Even Lordship kindly see, Milord. The first, Milord, there was no application at the instance of any of the creditor, Milord. It was an application at the instance of official liquidator to disburse the payment, Milord. They have admitted my claim and to disburse the payment. And Milord, while Milord passing this order, Milord, the Honorable Single Judge has said, Milord, there is exists, Milord, no irreversible situation. Here, Milord, two things have happened. If your Lordship kindly see, Milord, the status report, it clearly indicates, Milord, at page 38 is the first status report filed. My Lord, paragraph 3, Milord, the status report says, Milord, the property of movable assets has been sold.
Yes. Yes.
Milord, page 38 is the first status report filed by the official liquidator, Milord. Paragraph 3.
The status report of the status report.
SU 1.
অ্যাপিলের কপিটা দিন না, ওখানেই পেয়ে যাবেন। অ্যাপিলের কপির মধ্যেই রয়েছে স্ট্যাটাস রিপোর্ট।
Stay application.
স্টে অ্যাপ্লিকেশনে। স্টে অ্যাপ্লিকেশন নেই, আমারটা দিয়ে দিন।
Oh, yes, yes, yes. তুই এই ম্যাটারটা শোনো, এই ম্যাটারটা কবে রাখলাম? ব্যানার্জি we kept the other matter when in your other matter, yours other matter.
Item number 14 and
14
15.
and 15,
Uh,
Lordship.
stay-
14
stay রেখেছে।
and Thursday.
When we have fixed it,
11th July, Lordship. 7th July or 11th.
let this matter be listed.
7th July.
This matter be listed on 11 July বলেছিল। না না মানে ওদিন চলে যাবে। হ্যাঁ ঠিক আছে। ওগুলো আমি এখানে এটা ব্যাগটা নিয়ে চলে যাবো।
11th July, Lordship, this matter.
বইয়ের ব্যাগটা নিয়ে যেতে বলবে, বইটা নিয়ে চলে যাবে। ঠিক আছে, বইয়ের ব্যাগটা নিয়ে যেতে বলবে, বইটা হচ্ছে নিয়ে চলে যাবে। ঠিক আছে, এগুলো আলাদা না, আলাদা। তুমি ওটা দিয়ে একটু পাঠিয়ে দাও, তুমি ওটা দিয়ে একটু পাঠিয়ে দাও। আর শোনো, সুজয় বোধহয় বলতে ভুলে গেছে, তোমাদের একটা ম্যাটার বলা হচ্ছে না, জাজমেন্টালি ডাউন পর্যন্ত। একবার এসো চেম্বারে এসো। বলে দিয়েছিল ঠিক 9টার সময়।
এই দুটোর সময় বসবে তো? দুটোর সময় বসবে তো দাদা?
I have state card.
Yes.
Malad, I like to mention we get difficulty, Malad. I mentioned one matter of typical mistake is there, Malad. You lost a kindly.
This bench.
Yes, Malad. That is, my lord, Jongipur court omitted and Murshidabad court is there, my lord. There is no Murshidabad court. Or, my lord, Murshidabad court, Jongipur court, Murshidabad.
This we corrected according to your, whatever you have said.
Now, Jongipur court, that is Jongipur
Additional
court,
district judge
Murshidabad.
passport, it should be Murshidabad.
Yes, Murshidabad, not Murshidabad, that is Jongipur court. That is mark is like the right side, left side.
এসজি আছে এসজি এর সার্ভারটা খুলে করে দিতে বলো Just comments to be mentioned.
Transparency at his instance, the matter has come.
Oh, sorry, we are releasing the matter. Yes. Take down.
Yes,
Oh, this is a DNA report.
Yes, my lord, on the last occasion, my lord, this was, my lord, agreed upon, my lord, it failed, my lord, from your lordships that, my lord, we should, my lord, take out an application for mutual consent divorce. Because, my lord, the sole allegation was, my lord, of adulterous life, which, my lord, after the DNA report,
have
my
you
lord,
filed it?
no, my lord, we, my lord, forwarded them. They, my lord, declined, my lord, to file an application for mutual consent divorce. Now, my lord, has taken out this application, saying that the undertaking, my lord, which was given, my lord, the learned advocate did not have the authority, my lord, to give the undertaking. Only see, my lord, the dishonest stand, my lord, taken by them. And, my lord, if I am not wrong, my lord, my learned senior friend's client was there, my lord, inside courtroom when the order was passed.
So who is for the wife?
My lord, I am appearing for the wife.
You have challenged the decree.
Yes.
The decree will be set aside. Decree will be set aside.
Yes.
My lord, the
On the basis of the DNA report, the decree will be set aside.
may I make a very short
Yes,
submission?
yes.
My lord, the two courts, my lord, have upheld the order of the divorce by the appellate court of the trial judge. Now the appeal is
Say the first appeal. It's a first appeal. Two courts.
First appeal.
So first, sorry. So now your lordship has to decide as to whether the trial judge was right or trial judge
Absolutely
was
not right.
right. No, definitely that is also
Absolutely not right.
I know all right. It is not right, but if on
It is
that,
not only not right, by reason of this,
my lord,
she is entitled to divorce.
see,
She is entitled to divorce.
very well, my lord. Lordship's
divorce.
court will only, my lord, declare whether the order under appeal is correct or not.
Sir,
But only I am here today, my lord, because
No, we know our task and our duty.
I am not.
Thank you for
I
reminding
am
us.
not.
No, thank you for
disputing that.
reminding us.
Well, I am only concerned. I am only concerned with this.
And,
Well, I am only concerned with.
And your senior was here in court.
Mr. Ghosh was there.
So,
Well, Lord,
we
Mr.
just agreed.
Yes, Mr. Ghosh does not dispute that.
Then-
I am also not making any submission contrary to the submission.
Yes.
The problem today which has arisen because of one letter
No, you
one letter of the client. But only this portion I am aggrieved today
only with the word consent given by Mr. Ghosh. Because his client
He
said,
have agreed to file an application for mutual divorce.
no, my client's contention that my client's contention is that he has not
He
given
has not filed it very well, fine. So we'll treat this that he is not agreeable. Fine, matter end.
agreeable of what, my lord?
Not filing a mutual divorce.
No, I am not. That is what I am. That is my case.
See, what is
That
your
is my case.
What is your-
I am not agreeable to mutual divorce at all.
Exactly, that is what I'm saying. That is what I'm
Yes, I
saying.
am not.
But she's entitled to divorce on this.
But that is a different point. But today, what Mr. Ghosh has said, that his client is agreeable to mutual divorce, I am only saying no.
Subject to correction, client was also here
Whatever
that day.
subject to correction or not correction is not the point.
Client was here.
There is no, and that is what the client has said
This
that
letter
he,
is not a manufactured document.
It's a manufactured document. On the basis of the DNA report,
My lord.
judgment has to go.
yes, but on the basis of the DNA report, he has to take the responsibility of the son, of the child or daughter. But as far as the divorce is
As far as
concerned,
the DNA report is concerned,
Yes.
why he? Why she?
but
You are also,
divorce was on the adultery ground.
so that was filed by whom?
Yes,
You
and
filed
that
it.
has been proved.
No, the DNA report disprove it.
The DNA report is proved only so far as the girl,
Child is concerned. Yes.
he may have born out of my wedlock, but he
So DNA, on the basis of the DNA report,
my lord,
the suit has to be tried afresh.
no, definitely not,
has
my
to
lord.
be
With
done
my due
afresh.
respect, it's not. I tell you lots of why. I tell you lots of why.
Yes.
My suit was for divorce on the ground of adultery. The adultery has been proved. The question was as to whether the girl is my wedlock or not. It has been proved, yes, it is of mine. So at best, I am liable and responsible as far as that girl child is concerned. But so far as the divorce part is concerned, that is untouched.
Was the subject matter of the
Dulce,
trial.
But the DNA was not the subject matter of the trial.
That was the subject.
And that was not the issue. Issue was as to whether
That
the
was
adultery is proved or not.
It's alleged by the petitioner, that means you, that his wife never had any physical
Yes.
relation with him, and the child was born not by his loin,
Very
but
well.
due to his wife.
Now it has been proved it is by whom?
It's a
By whom?
perjured statement.
This is a perjury. You have alleged that your wife never had any physical
Yes.
relation.
Yes.
So it's a perjury.
So as far as
It's a
that,
perjury.
that is,
Absolutely.
yes, my lord,
Yeah.
that is proved that girl is of my.
Not only proved, this allegation is disproved
No,
that you never had any physical relation.
never had a physical relation.
Yes, that is a
Show the
that is-
witness
that is-
action, the evidence.
I have not gone
That
with
is
that
what?
part.
So the petitioner, you
Yes,
paid for determination of the paternity of the child. Now this has gone against you.
yes, it has gone against me.
So your cases, again, in this case, there was a prayer for petition for determination of the paternity of the child by DNA test.
There is a specific above
Just a minute.
This time first to
মিথ্যে কথা বলা। আমি দেখাচ্ছি স্টেটমেন্ট দেখাচ্ছি
আমি কিন্তু অন মেরিট আমি কিছু বলতে পারবো
সেকশন দেখাচ্ছি মানে
আমাদের
পুরোটা লাই absolutely
My lord, kindly fix up the date for hearing of the appeal. Kindly. Because I am not making any submission on merit today.
No, we were about to set aside the judgment. If Mr. Ghosh has instructed you properly, we were about to set it aside, the judgment. But since he had agreed to file a mutual divorce, we did not pass.
I
So we passed a formal order
understand that.
dismissing
I am,
allowing the appeal-
there is no dispute with regard to the submissions made by Mr. Ghosh as recorded by your lordship's order. But only I am concerned today with regard to the word consent. Whether Mr. Ghosh had really instruction to give consent or not. According to the client that he did not have any consent. did not have any instruction. He did not give any instruction either verbally or in writing. So therefore, my lord, this consent what has to be, otherwise he would be in trouble.
Again, Milord, a dishonest stand because Milord, the submissions were made in his presence.
Your client was present. in
Yes.
court.
No, no, client was present on that.
I have not seen. He might have seen.
No, no, no. He was there. He was there.
I do
He
not.
was
I
there.
have-
Milord, he had a talk with his
No, no,
client
yes.
outside
you had
the
a talk with your
courtroom.
client. What
What
you are
Mr.
saying?
Ghosh is saying.
Outside the courtroom, my lord.
What you are saying?
I tell you, Lord. Lord, may I be
when,
candid,
when,
Lord?
when you have
May I be
developed
candid,
when you develop this art of advocacy, Mr. Bose.
No, Lord. Lord, may I be candid?
Since when
Lord?
you have developed?
I must
Don't be
fair
candid,
to the-
please. Don't be candid. We have enough of it.
My lord, I have.
Don't show your candor.
No,
Don't show your candor, please. We have enough of it.
I do not know. I am not chill. I cannot say anything about it.
Today he is here.
Don't make a submission with a mask. Take it down. don't want divorce.
I want it.
They also
stay
want
with it.
divorce. They
Yes,
also want.
can't stay
divorce.
with him. But my lord will kindly, my lord, consider since 2007, my lord, I am, my lord, living under this, my lord, accusation.
No,
That, my lord,
full stop.
And on merit, I am not making any submission because I am not there.
Full stop. To take steps accordingly.
kindly, my lord, provide for some kind of, my lord,
Stop.
compensation because of the social stigma, my lord, I have, my lord.
The appellant shall be
Is with me.
then you file an application for that. We cannot decide on the question of were you receiving any alimony during
No,
the
I am
pregnancy?
not receiving any single penny, my lord.
Then we cannot decide that. Is allowed. Now, in view of such false accusation to the wife, the respondent number one shall
Dissolve the marriage, my lord, by a decree.
yes,
possible.
we have passed
My
it.
lord has done so.
And my lord, kindly grant me liberty, my lord, to
The
ask for, my lord,
decree-
pray
the
for
decree of
alimony.
divorce that the marriage between the parties stand dissolved on and from this date.
Grant me liberty to,
That
my
is
lord,
in
pray for
law
alimony.
entitled.
Kindly, my lord, grant me that liberty.
Law not entitled.
Grateful, my lords. Grateful. Alimony immediate. Immediate.
পুরোটাই
Budgetary দরকার না।
That's how a matter, your lordship directed that some deposit will
Yes,
be
we have
made.
extended the time. We have already extended the time
Yes,
once.
But my client, that is the appellant, they wanted to made an application for return of their fund, but the landed judge rejected that application.
Turn off the fund.
Directed the respondents to deposit the entire
money. Yes,
consideration money.
Yes.
Your lordship directed them to deposit in the trial court, and thereafter, deed of sale will be executed. But unless they applied for the money, Lord, the consideration money, which was submitted, deposited before the landed court below, but the landed court did not accede to their request and rejected the application.
No, you will be entitled to the money provided you execute the conveyance.
Well, unless only the memo of consideration, unless that is there, that should be there, my lord. The consideration is paid, then the execution could not be made. Your lordship kindly hears better. Let this
because the amount will be there as soon as you sign it. You will get the money and you have been given 3 months time.
I have submitted within the time, Lord, but the learned the judge did not hear anything.
Have you prepared the deed of conveyance?
They have prepared, but
Send
that
it
is,
to you.
huh?
Send it to you for execution.
No, that is not proper. The deed of execution, deed of conveyance is not properly drafted, my lord. That has been done by the respondent, the vendor, but that is not proper, my lord. They are coming with the 4 lakhs, not of this story that is your lordship has directed them to pay 40 lakhs. That is not there.
Correct it. You correct the draft.
I make, and they have gave us for our approval, but only thing on the appellant number 1 is state. That is being, that was informed the court below. She should be substituted. This some complications are there. However, my lord, one of the appellants for all submitted an application for withdrawal of the money, but that which the learned court directed that since the matter has been deposited in court, you are not entitled to that. That
Yes,
is,
you will not be entitled to unless you sign it. How will you be entitled? On what basis?
my lord,
You are
unless,
only entitled to the amount provided you execute the conveyance. And we have given you 3 or 4 months time
yes, but
after the execution of the conveyance.
execution would be done only when the draft is properly, the conveyance is properly drafted. My lord, your lordship consider the deed of, the memo of consideration would be there, my lord.
Memo of consideration would be 40 lakhs.
But that is not
the
there. They have drafted with 4 lakhs. In India.
Correct it. You correct it, give it to them. You should have corrected it, give it to them,
Yes.
and you should have executed it. You have been given, I think, 3, 4 months time to vacate.
Yes.
After you receive the amount.
After we receive the account, we shall be entitled some time. But unless the memo of consideration written there, even if I have to recast the entire thing, my lord, that is the difficulty.
That was I think we are directed you to give a handover in January. In
Lordship,
January, you are supposed to hand over.
January.
Then we
Yes.
extended it. Then we extended it by 2 or 3 months.
Yes.
At
Yes.
your request.
Yes.
It cannot go on like this.
Now,
It
that's
cannot go
true,
on
my
like
lord.
this.
But unless the conveyance is properly
Conveyance
drafted,
was there with you in January itself. You should have corrected it. Why you did not say so when the matter was taken up last?
my lord,
When the matter was taken up last, you never said that the conveyance is incomplete.
no, that we had received the conveyance after your lordship passed the order. Recently, this has been handed over to us. That's why we don't have extension of time. If your lordship guidance, then
No, how could we extend then formally the order of the trial court has to be varied or modified? We cannot in this jurisdiction do it. On what basis will extend?
my lord, since our
We have
application,
to give a direction upon the trial court to money be paid to you.
yes, if your lordship kindly considers that aspect also, within certain period, that will be,
First, you prepare the deed of conveyance.
my lord, the deed of conveyance was prepared by them. They have given us
Erroneous.
that.
You correct it.
That is.
You correct it.
This cannot be a ploy to extend the time. We will not play into these tricks.
Yes, my lord, we also do not want to drag the matter on. It is the thing, my lord. But they have given us.
After January, why you have not mentioned we extended? When we extended, you did not say so. We extended by 2 months.
We are not given the draft copy of the
You did not say
conveyance.
so. Did you say so at that point of time?
No, we are not,
You said only give us what is your submission? You said give us some more time so that we can vacate, we can file an alternative account. That was your submission, and we extended it.
No, we had not. I had not. We had not paid for any extension. The extension is made by the respondent on our prayer, your lordship.
Now that money is with the learned trial court.
Yes.
So you have to execute the deed and take back your money from the court. That's it.
You execute it and take back the money. What is the problem with that?
As your lordship, I shall advise him that is
Why don't you execute it and take back the money?
seriously draft is not properly, the conveyance was not properly drafted, that is the difficulty. The question, and it was made it clear in the application. In the application is made it
File
clear.
any application.
I have filed the application. This is for the first time for the appellant. This is not our.
Serve them, you have served.
Yes, I have served them. I have served the application.
File it, we shall see. You should have mentioned it earlier so that we are sitting today, we could have disposed of the matter. Why it was not mentioned earlier? Why did you file it?
Since this, we got this opportunity after.
No. We sat.
Even on Friday also.
On Friday we sat.
Last Friday?
Yes.
No, I missed it. I was something, I'm sorry.
But have you served them?
Yes, I've got something copy. I shall inform that we have mentioned this matter.
Yes.
Item number 1.
My lord, very short, my lord, reply.
My lord, on 30th March, my lord has given time for 8 weeks because the appellant, the contempt has already filed the SLP, which is still pending, my lord. But these are content matters. My lord has given a judgment of paying 6 lakh rupees to us, to the applicants, but they have not filed. My lord has passed the judgment in 20th July 2020.
Still pending.
It is still pending, my lord. From September 2020, it's still pending, my lord. Hearing is concluded.
It's for the judges to deliver. Judgment is not delivered.
No. I am for the applicants. Means the decree holder.
Part of matter item number 2.
My lord, 2 judgments were cited by Mr. Court. One was 2011 10 SCC and the other was 2001 6 SCC 512. I mean, so far as the first judgment is concerned, that is at the section 9 stage. what happens if right under section 9 is not exercised? That has nothing to do, my lord, vis-a-vis section 18 or the subsequent, my lord, section 20, because, my lord, we are really concerned with, my lord, I have given the judgments in the opening argument. But that has become academic because it fell from your lordships that instead of remanding it again, we will decide it, and the issue was boiled down to the valuation of Mr. Deb, and the only issue is that whether Mr. Kaur had accepted the valuation of land, but he had issues with regard to the deductions. Now, so far as this is concerned, my lord, this is section 9, and even this 2001 6 SCC, this is also at the prior stage, at the acquisition stage. Because, my lord, so far as subsequent to section 18 stage, my lord, it is now well settled that if you don't give notice, my lord, that is bad. But it has become academic because of what fell from your lordship. Now, so far as on the principles are concerned, my lord, I will not repeat on facts, but I understand, my lord, two things, my lord. Portions of my affidavit were shown to contain, my lord, twofold contentions were raised. Number one, my lord, I understand an argument has been advanced that the decisions which have been cited on our behalf, those are pertaining to income tax. And the formulation done so far as income tax statute is concerned should not be applied or adopted in considering a land acquisition act, which is a complete code by itself. This is, my lord, I understand, my lord, the argument has been advanced. Now, my lord, lordship would recall that the cases which have been cited, and when I cited, my lord, I had said this also, that subject to correction, these are on principles of valuation, and there are no cases under Land Acquisition Act covering similar principles. To some extent, I stand vindicated because, my lord, no cases have been shown also. Now, my lord, if this proposition is taken as an absolute proposition, that I will only look into whatever is available in the Land Acquisition Act, then with respect, my lord, we will not be able to look into, for instance, my lord, the definition of market value. My learned friend himself has cited, my lord, section 16B of the Stamp Act, which talks of market value, and which is defining that market value is the value which will be obtained if sold in an open market. Now, my lord, kindly adopt, even if you take that definition also. My lord, it will be, I say, my lord, the same principles will apply. If it is encumbered in the open market, you sell, it will not receive the same value. So therefore, as an absolute proposition, it can't be said. And there is not a single judgment saying that because it will be valued at par, property encumbered and unencumbered will be at par so far as Land Acquisition Act. Well, that cannot be an absolute proposition. It is not possible because the ultimate test is market value. And merely because market value was considered in land acquisition proceedings, that will not make the principles of valuation, my lord, redundant or different.
A fiscal statute. The other may be a confiscatory statute.
My lord, this
so this
I understand, my lord. It fell from your lordship on the earlier occasion also. My lord, when we
nature
are
of the statute has to be
my
seen.
lord, that will not determine the principles of valuation. My lord, I am on principles of valuation per se. Because, my lord, what is falling from your lordship, purpose of the statute, my lord, an approach may be whether it will be on the higher side or lower side, there may be a minor variance, but principles of valuation, valuations are concerned, there will be no variation so far as the principles are concerned. Either, my lord, an encumbered and unencumbered property will be valued differently in all categories of valuation. Whether you do it for income tax purpose, land acquisition purpose, mortgage purpose, or simplicity to determine the value of security or otherwise. That can't be the, my lord, purpose. Now, my lord, apropos this, an alternative argument was done that this should not be treated as an encumbered property because of two things. Number one, in my affidavit, I have said that the lease had expired. There is no dispute. My lord, property doesn't become encumbered or unencumbered because, my lord, I was still in possession. And, my lord, this was at the stage of renewal and negotiation. But possession was mine. The second argument that was advanced, my lord, I understand, my lord, I have the pages, I need not, I just give the point. My lord, the notice was shown that I have handed over possession to the requisitioning and the acquisitioning authority. That has to be under statute. For instance, if instead of me, if X, Y, Z would have been in possession, once it is requisitioned or acquisition, my lord, formally it has to be handed over. And then, my lord, after that, my lord, I would be given over as the acquisitioning body, acquisitioning agency, I would be handed over by the state. That is as per the procedure. And that is why, my lord, all the documents are that this is possession being given to the acquisitioning authority or the requisitioning authority. That in law will not make an encumbered property unencumbered. Because if that is taken as a proposition, then in all such cases, it will be treated as unencumbered property. That is not. In fact, my lord, had it been a third party and he is dispossessed, my lord, under section 18 and 20, he also has a right to, my lord, seek compensation, if at all payable, because he is being dispossessed. He also has a right. Here, my lord, I had, lordships will recall in my opening arguments, I had stated that it does not make any difference that I was earlier in possession and also happened to be the requisitioning or acquisitioning body, agency, at whose behalf, my lord, the property was done. That does not make any difference at all, so far as the pricing is concerned. Instead of me, my lord, if somebody else would have been there, then also it would be treated as an encumbered property. And merely because I happen to be there, and similarly, my lord, the fact that the lease has expired also does not make any difference. Whether it was vacant at that point of time, that is the test. Because, well, a trespasser, a property with a trespasser is also an encumbrance. Let us treat it at that.
Then you had the opportunity, Mr. Chaudhary, to raise your claim before the collector at the time of acquisition. That is the law.
No, but I was not even given notice. But I have, my lord, I can't suffer both ways. What is falling from your lordship, if this contention would have arisen, that is, my lord, it would only be, my lord, I gain here, I lose here. But monetarily, it would have been balanced. I am not claiming compensation, my lord, because I have been dispossessed. No, I am just giving this example. I am just giving this example to say that if a third party would have been there, then also this would have been the proceeding. I am saying, my lord, what are the tests of market rate? Because, my lord, lordship would recall, in fact, the original note which I have filed, my only point of argument is that it should be remanded because I have not been served. That is the only point which I have argued. On principles of law, my lord, there are three things, my lord, which I respectfully submit. Number one, my lord, it does not make a difference merely because the cases which I had cited are on income tax. It's on principles of valuation. And at the end of the day, both under the Land Acquisition Act, my lord, section 23, and my lord, even if lordship looks at, my lord, that is why, my lord, my learned friend had cited 16B of the Stamp Act. Market value has not been defined in the Land Acquisition Act. Now, as a principle of market value, an encumbered and unencumbered property is valued differently. And my lord, here, my lord, if my valuer's valuation is taken, it has to be taken. You can't pick and choose the one which is advantageous and disregard the other. Because, my lord, here, lordship will kindly bear in mind, for convenience, we are doing it here. It's not that my valuer has been cross-examined or anything. And there is no contrary valuation also either. Because, my lord, so far as their valuer is concerned, he did not even visit the property. That is on record, my lord, the state has made the submissions. I am not on that. But I had not been cited or, my lord, notified at all. And, my lord, that principle is well settled. So, my lord, if lordships are pleased to accept the valuation, my lord, it's on a sound basis and the land. Otherwise, my lord, it's an absurdity merely because, my lord, it is. And in all fairness, the valuer has given the correct picture. Lordship will compare, the comparative chart has been handed over by my learned friend. That their valuer had valued the land at 80 lakhs. So this is, and it does not make, well, at the cost of repetition, I am saying, it does not make any difference whether I am the, I was in possession earlier or I had knowledge of the earlier proceedings, because that is covered under what is to be neglected. Next section, section 24, it is covered under that. That please ignore all this. What is happening subsequently or what had happened, ignore all this. So, it does not make any difference. Had it been a third party also, what would be the principles of valuation? My lords, kindly apply the same principles. And on that, there cannot be an issue, my lord. If it is encumbered, it has to be valued in that particular manner. And only thing, my lord, because, my lord, I will just take 7 days time to file an additional note, because, my lord, the initial note which I had filed is all restricted to my only point which I had argued was, my lord, I have not been served or I have not been notified. So, my lord, whatever little, I just give a 1-page note, my lord, to the extent I have argued on the principles of valuation vis-a-vis Shondeep Dev's valuation.
That is, we'll fix a date only for the purpose of filing on.
That's not necessary. We can hand up to your lordship's court officer also.
Better we keep it because.
Very. Then, Lord, maybe also, Lord, give a one or 2-page note dealing with the why deductions can't be made.
Plus 7 days only for the purpose of filing on notes. সেদিন ওই application টা দিয়ে দেবেন।